case. Okay, all right, so we are in, I regret that the first and second rooms were a little kind of duplicative, but this is going to be the rules of evidence. 1 second. These will be the rules of evidence and making objections. Sorry, guys, I've got assigning people into breakout rooms. Hello, just please turn your video off. All right, and let me get my shared screen. All right, there we go. Okay, so this is going to be the rules of evidence and making objections. The first breakout room is really focused on, in case you want to go back and watch it, focused on really admitting and objecting to evidence that's trying to come into trial. So exhibits that are trying to be introduced as exhibit numbers or pieces of evidence. What I'm going to talk about here is far more global about evidence itself. Let's see how you get the chat so I can see this. And yes, if you have questions, please stay on mute and video, but if you have questions, you can type them into the chat bar or just say you have a question and then we can talk between us on video or audio at the end. But if you have a question during this presentation, feel free to say you have it or ask the question if you don't want to wait till the end. So yeah, again, I'm Taylor Robertson, Vice Chair. I got this purple jacket like 2 years ago for Christmas, but I wore it for one mock trial, I guess, 2 years ago, and that's apparently how people know me. So I now wear it for all mock trial purposes. Okay, so the rules of evidence. First couple of tricks. First, not only do you need to read the rules of evidence that are in the fact pattern, you must understand the rules of evidence. And what does that mean? Well, why do these certain rules exist in the first place? Why do we not want some evidence coming in at trials? And then when we do have rules for why things don't come in, why are there exceptions to those rules? If you understand why, for instance, we don't let hearsay in, it will help you better understand the rule. And further, if you understand why, while on the one hand we don't like hearsay coming in, we have a whole bunch of exceptions, like an excited utterance when somebody is dying under the belief of death, why we allow somebody to say what they heard that person say, that will help you grasp a better and broader understanding of why the rules exist and how best to argue them, one, to either get something in or to keep something out. I'm gonna bring some people here into the room. So that means you need to do more than just memorize the rule. You need to understand how it applies specifically to an instant. Don't be embarrassed if this has been you, but at least 20 times in my 5 years judging, I have asked, what is the objection? Hearsay. Why is it not hearsay? It's not being offered for the truth of the matter. Full stop. And as a judge, it's kind of like, okay, but what is it being offered for? It's like somewhere down the line, somebody learned that they could just say, it's not being offered for the truth of the matter, and that wins all hearsay objections. And that's wrong. But you've got to understand how it applies specifically. And we're going to go into these in detail in the slideshow. These are kind of some global comments, but you have to think about it from a judge's perspective. Like, you got to help me get to your side. You have to help me understand why this thing should not come in or why this piece of evidence or testimony should absolutely come in, because they don't have the fact pattern memorized. They need context. I think a lot of students just have learned words and phrases that help or hurt certain objections without tying it specifically to whatever the thing is that's trying to come in or trying to be kept out. And I think that is a huge, critical aspect that moves pretty good teams into the really good and great team level, including the ability to anticipate the objection that you might get. You may be right in this, if you were in my first session, or you can go back and watch it, talking about the case map and basically gridding out things. When you're doing cross or even direct and you have the question, you may think, if I heard that question, I might object to it based on whatever, 403, hearsay, subsequent remedial measure, whatever it might be, how are you going to respond to it? Because sometimes, one, you might want to rewrite it so you don't get the objection. See if that's possible. Two, if you can't, or you need it in and you know it's going to get the objection, you have to anticipate the objection and be ready to go with a response. And I'll show you a tactic in this slideshow about how to front load questions to help yourself with avoiding and defeating objections when you know that they're coming. Because sometimes you can't get around it, right? You can change a leading question into a non-leading question if you're on direct. That's easy. But sometimes you need something to come in that's hearsay. And there's a whole bunch of exceptions, but if you can craft your questions in a way that pre and front loads the witness for that exception, and again, we'll talk about this in detail, I just think that's what real and awesome super lawyers do in real life, and it's what the great and really good teams emulate in mock trial. So one step that I think everybody likes making objections, right? Get to stand up, get to yell objection. It's fun. There are times when the question is objectionable and you do not need to object. Strategically, you don't need to object. The first instance is what's happening that is objectionable, does it even hurt your case? There's a lot of objections that I'll get sometimes, and I know the fact pattern probably better than most judges, and I don't think it hurts your case. And so I know that students want to object to show the judges that they know something is objectionable. And I think that that's fine. And I think that does help you on points. But in some scenarios, it just doesn't make sense. Yes, there are tactical reasons to object, to either interrupt flow or something, but there are plenty of times when you just don't need to make the objection. One great example is you, in every trial before, have won this one objection. And for whatever reason, in this trial, the judge overruled you. But yet you then keep making that same objection on essentially the same concept 5 more times, or your team does 5 more times throughout the case. Once you lose an objection that you typically have won or you think you should win, maybe make it one more time. And I'm not talking about the exact same question. I mean, please don't do that. If they ask a question, you object, and you get overruled, and then they ask the question again, please don't object again. I think that never helps. But if you are losing a certain objection and a judge is letting something in on an issue that you've never lost before, or it's different than other judges, there's no reason to keep losing. Well, there's no reason to keep standing up and having the judge rule against you. It's not a good look. Another one, and I briefly mentioned this in the last one, is don't object to something that you did yourself previously. It's the goose versus gander. I mean, if you got some piece of evidence in by saying, well, judge, the witness relied upon it because it was sent to their home, and then the other side hears this and goes, oh, okay, and then tries to get a piece of evidence and just assume for a moment that they can use the exact same reasoning behind it, don't object to it. I mean, if I'm the judge, I'm actually going to say, isn't that exactly what you told me when you were trying to get evidence admitted? You have to be strategic, and you don't want to make yourself look bad and lose credibility. Credibility is so big in mock trial, and I'm not saying the witness looks truthful. It's competency and confidence that you exuberate to people. I mean, there's plenty of studies that in actual jury trials, right, jurors latch on to these lawyers that they like, and it often is because they're good lawyers, they're making good questions, but it is the persona that they kind of embody, and that's kind of the soft or unexplained thing that can make teams from good to really, really good or to great. The other part, especially on objections, is reading your judge. Is the judge that you happen to have letting everything in? Because if so, your objections need to get pared down to really only the worst stuff. Is there a judge that is not letting anything in, that's sustaining every hearsay objection? Okay, well, then you need to be objecting more if the other side is asking hearsay questions, because you want to don't let the judge rule in your favor 2 or 3 times and then let your foot off the gas. But 2, in game, you need to be thinking about, man, the judge is sustaining every hearsay objection. I need to be very careful asking questions that are going to elicit a hearsay objection. That's very hard. right, to make those adjustments in game. But through practice, you will see there's, 5, 6, 7 kind of judge personas out there, and they may change. I personally have taken on kind of a certain judge persona in one trial, and then in the very next trial acted completely different. And I do that just to, mix things up. But for the most part, you'll get a read on your judge pretty early. And that should inform you throughout the rest of your trial. The other big one, because this is very different on all judges, how much time are you going to get to respond? There are some judges that objection, hearsay, response. It's not hearsay, Your Honor. It's exception to the hearsay rule under whatever rule number. And then they rule. Some judges may let the objecting attorney provide a quick response. Then they rule. Other judges may let you go back and forth 2 or 3 times or ask you questions. Well, but why isn't it hearsay because of X, Y, and Z? That is going to dictate how you deal with objections. If the judge lets you make an objection and lets the other side respond and then rules, when you object, you need to start adding some context. I'm sure you've heard of the speaking objection, and some people frown on the speaking objection. But if the judge allows you to object and then makes a ruling after they respond, you're going to have to add, Your Honor, this is hearsay because it is, and add just 1 or 3, 5 more words. But if you get 3 or 4 times to respond, then you probably don't need to do that. But you've got to respond to how things are going in the process. And yes, you all have that tactic of, Your Honor, may I respond, which I think is fine. But man, I'm telling you to only use that when the judge is about to rule, Your Honor, may I respond, if you've got just the 2-sentence answer that's going to solve the judge's issue with the objection. Do not say, Judge, may I respond, to essentially reiterate what you've already said or to make a rambling, incoherent answer. Because there are times when I've already made up my mind that I'm going to, for instance, overrule the objection, and the party that is saying, may ask the question, so doesn't think it's an objection, says, Your Honor, may I respond? And it's like, well, I was already going to rule for you, but sure. And then they tell me something that makes me rule against them. So there is that risk that you have to be very cognizant of, that, if you get a couple of times to respond, I don't think you need to, Your Honor, unless the other side in their response brings up something completely new, right? You're arguing about the hearsay exception, yada, 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 and then in their kind of final retort, they throw in something that's completely new. Then maybe, Your Honor, may I respond to the new argument they made about whatever. I think that is okay. But be careful asking to respond, because you may actually hurt your case. Okay, I see a question. Is it better to respond immediately or to wait for the judge to ask for counsel's response? Where some teams do both of these. This goes back to reading the judge. If the other side objects, right, and for instance, the judge then looks at you, I think you can start responding. I don't think you need to say, may I respond? But if for whatever reason, the judge looks at you and you start responding and the judge corrects you, counsel, let me tell you when it's proper to respond, well, then obviously do that from then on. But sometimes I think teams get overly formalistic of, Your Honor, may I respond, may I respond when it's their turn to speak? And I don't think you need to do that. So again, a lot of these, I should preface that a lot of the objection stuff I'm going to talk about, is my position on certain things, and every judge is different. And that's why I think it's probably frustrating for students, because you want consistency, but in real life, you get judges that do crazy things. And by crazy meaning, it was unanticipated compared to other judges and what you've done. And it's just a fact of life. And so great teams use this to their advantage by making adjustments in game to conform to kind of how the judge is running that trial. How important is citing rule numbers? Does it affect a judge's decision? Personally, I could care less about the rule number. No judge in real life, maybe the exception of 403, because everybody knows it as 403 relevance. I think if you polled actual judges right now, what is the rule for hearsay? I'm not sure most of them would get it, because in real life, we never do that. No lawyer in real life, Your Honor, objection to hearsay under Rule 803D. I mean, if I had to cite him to something, then maybe I would cite the rule. But when you're just making an objection, you don't need to. But that is me personally. I think some judges like hearing the rule number because to them, I think it shows that you really have a firm understanding of the rules. So I cannot speak for all judges, but I think the trap becomes students that know the rule number, they have that objection and response memorized, right? It's rote memorization. Your Honor, objection to the rule of 804D, it's hearsay because of, and you kind of just hear it kind of monotone. It doesn't sound like you actually know what you're talking about. It sounds like you've memorized some, something that your coach or your lawyer coach has written down for you, and then you've just memorized without actually demonstrating a knowledge and understanding of the rule. So I don't care about the rule number. I certainly would not overdo it, but we just don't do that in real life. Let's see. Yeah, there you go. Our lawyer never cite a rule number, right? Unless you're tying it to case law or you're citing it in a brief. Okay. So yeah, picking up where we left off, great teams and lawyers anticipate objections and prepare for them. So this is my first tactic for you, and I'll tell you, it's a doozy. I think this is a really effective strategy. I use it in my practice, and I think once you get it, it will save you a lot of heartache. So front-loading your questions. This is very useful for the anticipated hearsay objection when you are going to try and point to some exception, pretty much other than party admission or a statement by a party opponent, whatever. It's said differently in Texas and federal, but whatever that rule is, right? That one's pretty obvious. But if you can front load it, you will see how better this works. So we're going to look at an example from last year. I'm using last year's fact pattern because I just couldn't find a good example in this one. Okay. So back to our party opponent. This is, I can't remember what statement this is, or this is Chase Ford, but we're going to assume for this purpose that Instagram is not the defendant. Okay. So you don't have the party admission exception. Okay. So put that aside for right now. But here was the statement from Chase Ford. And this, if you remember last year's fact pattern, this is about the comedy festival. And Chase Ford is claiming that it was all going downhill. He wants to cancel, and Instagram says, you're not going to cancel through all these threats. So this is Chase Ford's statement. Started screaming at me, told me I couldn't cancel. Instagram was really concerned about losing money. No matter what I said, refused to listen, threatened to ruin me if we canceled. Things like Instagram is famous, tons of followers, lots of connections, and canceling would ruin that fame. And if I canceled, Instagram would use all that fame to make sure I never held another party again. So you want Chase Ford to say this on the stand, but it is utter hearsay. It is all the things that either Instagram said or did in a assertive manner, which again, remember, hearsay is not just words, it can be assertive actions. So you want Chase Ford to say this, it's absolutely going to draw a hearsay objection, especially because it is damaging to the defense, okay? So how are we going to get this in a clean manner? Okay, so the exception that we're likely going, there could be others, but we're likely going to use is the then existing state of mind. Showing the declarant's motive, intent, or plan, okay? So look at the bottom. What happened next, Mr. Ford? Remember, direct, open-ended, you want your witness to talk as much as possible. Instagram, rather than, this is in contrast to what happened next. Well, Instagram then told me that she would ruin, or he, whatever, would ruin that fame. Objection, hearsay. Now you're going to say, Your Honor, this shows the declarant's state of mind. Okay, well, now you're going to have to explain to me, the judge, well, why is it the defendant's state of mind? Because I haven't heard what's happening yet. So do this. What happened next, Mr. Ford? Instagram made it clear she had no intention of canceling the event. And if I did cancel, that she intended to ruin me and my business. What specifically did Instagram say? Objection, Your Honor, hearsay. Your Honor, as the witness just made clear, this goes to the then existing state of mind showing the declarant's intentions and plan. Therefore, it is an exception to the hearsay. Look how beautiful that is for the judge. You don't have to then try and say, well, it's going to show intent. If you let the witness finish, you've already given it to the judge. The judge knows, just heard from the witness, intent, motive. And you then get to pull that right into your hearsay objection. The other beauty is the other side likely will not have any idea what you're doing in that answer. She had no intention of canceling the event, right? You might get the hearsay objection then, but you've already got the intent part out and you're probably going to be able to get to the exception. But now the judge doesn't have to assume anything, and you don't even have to provide any additional stuff. Your Honor, the witness that's about to talk about the hearsay just told you that it showed the declarant's then existing state of mind, such as motive, intent, or plan. I'm telling you, when I do that in real trial, I don't think it's ever failed. When you front load it in that manner, and you can do this with any other exception, right? You think about like the excited utterance when somebody's dying. What happened next? I got to the accident scene and, Bill or, the decedent was lying there with blood coming out from, the wound on his side, gasping for air, telling me, I don't think I'm going to make it. I don't think I'm going to make it. By the way, so-and-so is who hit my car. You've already laid the groundwork for the excited utterance, as opposed to what happened next. Well, I got to the thing and the person that was injured said. Now, when you get the excited utterance, you have to lay the groundwork for, it was under imminent belief of death. But you've already done that through he's injured, he's gasping for air, he's looking at me saying he's not going to make it, or, he looked like he wasn't going to make it. You see what I'm talking about. You can front load with some answers from the witness that is going to lift up your exception to the hearsay rule. Okay, next part. Focusing on the appropriate part of the rule. I don't think I've ever sustained a 401 relevance objection. And the reason for that is everything is, frankly, is relevant. Unless you are, I take that back. I think I have sustained one or two when really silly things started to get asked about. But unless you are asking about, something, because otherwise it's going to be outside the fact pattern. It's got its own problems, right? But 401 relevance, I don't think I'd ever make that objection unless they start talking about something that has absolutely 100% nothing to do with your case. Instead, it is the 403. I see students really not understand what the purpose of Rule 403 is, okay? So you need to break it down almost like a mathematical problem, okay? It will be excluded if the probative value, and the probative value is essentially what does it go to show, right? Is it making a fact more or less true and is relevant to the act? Like probative value means like what is the benefit that piece of evidence is going to do? Is substantially outweighed by the danger of one of the more following. And most of the time, people just shorthand it as unfair prejudice, okay? But undue delay, wasting time, etc. So if you break it down, big prejudicial effect, a lot of it outweighs the probative value, okay? Where teams get caught is they basically argue that it's prejudicial. The evidence is prejudicial, it should be thrown out for 403. I have a newsflash for you. Every piece of evidence is prejudicial. Otherwise, you wouldn't be using it. Every evidence is prejudicial. You are using it to gain an advantage to either prove your case or disprove theirs. That is why the rule is phrased as substantially outweighs the probative value. Now, in reality, every piece of evidence is prejudicial, but it also might have great probative value. But just arguing a piece of evidence is prejudicial is not the correct way of understanding this rule. It is that the prejudice substantially outweighs the probative value. So even if it outweighs, that's still not enough. It must substantially outweigh the probative value. And if we think about this as a math problem, if the piece of evidence has no probative value, it's pretty easy to argue that the prejudicial effect substantially outweighs it. I know as a judge, I have asked under a 403 objection to the side trying to bring it in, what is the probative value of this piece of evidence? And there are times when people have, I don't know. I mean, well, if it has no probative value, then almost automatically it's going to be substantially outweighed by its prejudice. So you need to be ready on a 403 to specifically elicit and describe the prejudicial effect, why it substantially outweighs the probative value. One argument for this is it has no probative value, or it has very little probative value. That's a good argument for when you're trying to get it sustained. The ways to defend it is, sure, there's prejudice, Your Honor. Every piece of evidence is prejudice. That's why I'm using it. But it doesn't substantially outweigh, and look at all of this probative value that I get. Okay, I had a couple of, the first tactic, front-loading the questions. Recommend front-loading your questions or just change the wording. You have to work with your witness on this. I mean, you saw the question was, what happened next? So this is really driven by the witness. You have to work with your witness to get that information of, well, I then learned what so-and-so's intent and plan was going to be about yada, yada, yada. What did they say? So it is a teamwork issue with the witness. I think everybody respects the role of the witness, but I've seen from time to time other people don't. Do not undervalue the the value of the witness in this competition. Even in mock trials where the witness isn't graded, it doesn't receive a score, it just goes to the cross or direct of the attorneys. The witnesses can really push a case one way or the other. One, through helping your own attorneys, and two, through demolishing the other side's attorneys. Not taking their bait, being resistant without being obstinate or being refusing to answer, etc. But that's for a different case. Okay, on the objections themselves, and we talked a little bit about this. You need clear and concise objections. This again goes back to the confidence. It shows that you understand what's going on, and you need the judge to focus. So, objection hearsay. Unless you have been warned by the judge that they don't want any speaking objections, then don't do that. I mean, do that if they say no speaking objections, just say objection hearsay. But I will allow you and I do it in my practice, I'm going to speak the objection a little bit, because if I'm objecting, I get the first word. I want to frame the issue the way I want it to be framed. And I'm going to speak a little bit on the objection until I am warned or instructed by the judge to not do it. Now, this is not a time to make a 4-sentence or 1-minute long objection, but a clear objection. Objection, the witness was asked to testify about what somebody else told them. That is impermissible hearsay. And I even put under Rule 803 because that's what you all do, but no, you don't have to do that, okay? And again, this is the tactic. You're forcing your opponent to confront or respond to exactly what you want. If you just say objection hearsay, and the judge says response, they say it's not hearsay, and they start arguing an exception to hearsay that you don't want them to, right? You've lost kind of the ground. You want to be able to focus the judge's question. Your Honor, objection. This is barred by Rule 403 under the relevance. It has absolutely no probative value, and it has substantial prejudice, and therefore it outweighs because it has no probative value. Now I've forced the judge to look to the other side and go, okay, well, first let's start. What is the probative value? And the other side may be like, oh, I was ready to argue that the prejudice wasn't there, but probative value, you dictate your objection. That's kind of the end game. And this all is with the proviso that your judge may pull you down or limit you on how much you can respond, but it's your objection. This is it's litigation, it's strategy, it's gamesmanship, like proper gamesmanship. Not gamesmanship's often used as a wrong thing, but it's tactical. And you need to be tactical not only with your themes and theories and the evidence you use, but how you make objections and how you use evidence. Teams that know evidence better than the other team, routinely win, because it is such a disadvantage or such an advantage to have a more powerful understanding of evidence, because now you're keeping things out that the other side has never had excluded and now doesn't know how to deal, or you're getting all your stuff in that a good team is probably keeping out. And the mismatch in evidence knowledge it spills over into all the rest of the competition. Okay, now on responses. Concise responses. This doesn't mean that you just say it's not offered for the truth of the matter asserted, but a concise response, one that is not rambling or disorganized, again, imbues this credibility. It's not hearsay, Your Honor. He's not being offered the truth of the matter. I mean, every time I hear that, the very first question is, what is it being offered for? And if I've done that once before and you say it's not being offered the truth of the matter, I'm probably just going to sustain the objection, because you're not being offered the truth of the matter is not an answer. I mean, it's part of an answer, but it's not, it alone does not survive the hearsay objection. And here's the better one. It's not hearsay, Your Honor. The statement demonstrates the declarant's state of mind and thus constitutes an exception. That's pretty narrow. You might need more details depending on whatever is going on. But you are focusing the judge back to what your exception is. It's not even just then existing, right? You're saying it's the state of mind, the intent, the plan. You're getting as granular as you can, and that shows confidence, and that gives the judge a reason. Let's see. What will you say in defense of Rule 403 if the other side says your evidence has no probative value? Well, I mean, probative value is how does it help the fact finder make a fact more or less true and relevant to the action. So if you're using the piece of evidence, I hope you think it has probative value. What does it move the ball forward for you on? Your Honor, this is going to show X, Y, and Z. Like, what part of your case map does it fit into? That is probative value. So I can't tell you what just like the hearsay response, it's fact specific. I mean, probative value is what is the use of this fact what is the use of this piece of evidence to helping people determine facts in the case? Your Honor, this goes to show the location of the defendant at the time of the, whatever. What does it mean to front load? I went through that at the beginning of the thing. If I have time, I'll go back to it, Diego, but otherwise it's at the beginning of the recording. And we talked about this already. Read your judge. Your presentation or your, how you conduct your team in trial should not be the same in every trial. It should be different. There should be differences every single time because you are reacting to what the judge is doing. You are reacting to what your opponents are doing. And it should never be the same. You should have a game plan, right? But you should not have a rigid game plan. This is what we're doing. We're doing this, we're doing that, we're doing this, and we're finishing with this theme, right? I've abandoned themes before in trials because it was either getting flipped on me or I discovered a new theme based on what their witness had said. So do not be so rigid and conformed that you won't be creative and you won't respond to what's happening at trial. And reading the judge, here are the times, right? Not only do they ask you questions or do they make statements to you during the objections and responses, do they make statements when they rule? I'm going to overrule the objection because, or I'm not going to sustain the objection because, whether intentional or not, those are clues to you. Nonverbal cues. Everybody's going to see this recording, so I'm not changing anything. I don't necessarily do it. I may do it unintentionally. But if you object and there's a back and forth and the judge says, I'm going to overrule that objection or I'm going to overrule it at this time. The other side then keeps asking questions, and on a question the judge looks back over at you, that's a good sign that you probably should be objecting. Now, you need to know what you're objecting to. You don't need to stand up. But the judge most likely has thought in his or her head, that was close, but it's not quite over the line, so I'm going to overrule the objection. And then all of a sudden they cross the line, and they're anticipating you to object. And so I know I've done it because I remember looking at a team and the student just kind of looked back at me. And it's kind of like, not every time they look at you is going to be objectionable. You better know what you're objecting, but that is a clue. That's a big clue. And they do it in real life too. Okay. I filled up a lot more time than the last one here. So we've got 15 or 17 minutes. Again, I'll answer questions, not about this year's fact pattern and not, don't kind of allude to it in questions. I haven't seen that yet, but I just figured that would happen. Let's see, make sure I've answered all these. Front load. What does prejudicial effect mean? Well, let's go back to the rule. It talks about undue prejudice. Prejudice is, it hurts another party. Just think about prejudice as it's used in normal nomenclature, right? It is a favoritism of one person or the disadvantage of another. But it's undue prejudice. So it's too much prejudice. And then they list a whole bunch of other things on there. Confusion of the issues, wasting of time, misleading the jury. Those are good examples. You're not supposed to do research outside the case, but there's plenty of mock trial treatises and things out there about evidence that can be helpful. Your attorney coaches will help you understand more about the evidence. So I would give that one that. Let's see. Reading the judge may not be possible in Zoom. With the delays in Zoom, how do we interrupt when it's coming in late to objectionable statement? So I'm not answering anything about the technological standards and processes we're using. We're going to do that at a later date. That is because we are still trying to work out some of them. So I don't want to give you an answer today that's going to change tomorrow. I will tell you that we anticipate the judge will be on screen at all times. Yes, it's not going to work this year because you're not going to know me looking at your screen type of thing, but it still goes to in real trials, right? Somebody asks a question or a witness gives an answer and a judge kind of makes a face, like those are all nonverbal cues that you can pick up. So yes, it may be different this year, but that's not to say there won't be cues, certainly in statements that you hear from judges. But yes, with respect to interrupting, making objections, we're going to cover that. One thing I'll tell you that is whatever standards and rules we come out with, you guys need to practice and practice and practice using your Zoom thing. I had a 3-week trial on 3-week arbitration on Zoom. So witnesses weren't there, exhibits were up on the screen, all the cameras are on there. And it was hours of practice to make sure that it went off without a hitch. You knew how to you knew how to look at the witness, you knew how you sounded, how you looked on screen. So just like in real trial, you might practice presentation, standing and looking at the eye contact with the jurors. You got to do that now with respect to the technology. But we'll get to the standards of how best to interrupt or make objections, who needs to be on camera, who needs to be on screen, et cetera. I have seen judges before get annoyed or refuse to give clear rulings when asked. We ask for rulings when it isn't clear. I'm not sure what that's asking. I mean, if a judge does not say the objection is sustained or overruled, I think you should ask, Your Honor, I'm sorry, perhaps I missed it. Was the objection sustained or overruled? Because in reality, you have to have that on your appellate record. You got to have that in the transcript in case you have an appeal, because otherwise you just don't know. So I think it's fine to very kindly ask, Your Honor, you can say, for the record, was the objection sustained or overruled? Now, they may not tell you why. They may just say objection sustained. If you ask them why, you're not going to get an answer to that. I don't think that works. But if it's not clear that it was been sustained or overruled, I think it's fair to ask which one it is. Can you explain Rule 613? That might take a while. Let me see what time I have. Can you please explain probative value and what is the better part? So I'm going to tell you to ask your attorney coaches or coaches, teacher coaches about probative value. Probative value is the reason that you're offering the exhibit. What does it help make? What fact does it help establish? Okay, so if it's connecting, so our car crash case, right? Like somebody says it's green, somebody says it's red. If the fact is going to what a third-party witness saw the color of the light, that is extraordinary probative value, right? That is central to the case. That is a key aspect or element, maybe not element in a cause of action element, but an element in the theory of the case. That is probative value. And there's really technical reasons I could explain it better, but if you look at evidence is relevant, tends to make a fact more or less true and is, important and relevant in deciding the matter. That is a shorthand way of talking about probative value, but your coaches will help give you more of a detailed answer on that one. When is it appropriate to ask for limiting instructions? I mean, you can ask, something to be stricken from the record, but I know what you're probably asking is for a limiting instruction on what the questioning attorney can use the evidence for. If I recall, there's no rule that says you can or cannot do it. I will confess that in a championship round in law school that I had, I just randomly asked for a limiting instruction, and it was part of the reason we won. So you can ask for one. That's a great example of the judge saying, no, don't ask for another one later. But I'll tell you that if you ask for a limiting instruction, that better be well rehearsed, practiced, and with experience to know exactly what you're asking the judge to do. Because if it's kind of rambling and not clear what you're really asking, because there's kind of a very specific way you do it in trial, it's got a chance to hurt you more than help you. Let's see, is a witness's criminal history considered undue prejudice? I think that would be an example of prejudice. But remember, undue is a relative term. Undue prejudice, one side's certainly going to think it's prejudicial, but it's not undue. The other side is. Undue is, again, it's kind of like reasonableness. These are things that you just have to argue. You have to find a reason to explain to the judge. Evidence, there's almost never a scenario where I can give you a definitive rule about something without specifics of the case. I mean, is that witness's criminal history relevant to what the crime is? Is it relevant to the witness's credibility? Was it like a fraud or a forgery case? Was it 15 years ago? Was it 2 months ago? Who was the victim? I mean, there's thousands of things that can add up in there to make it undue as opposed to just prejudicial. So will the probative value always outweigh the prejudicial effect? No, absolutely not. In fact, the rule anticipates that the prejudicial effect will outweigh the probative value. Thus, the standard being it must substantially outweigh. So even if the prejudice outweighs the probative value, that's still okay under the terms of the rule, because the standard is a substantial outweigh. What else can we say in defense of an ultimate issue response other than not objectionable because it embraces the ultimate issue? What else can we say in defense of ultimate? Well, if I recall, I know in the federal rules, and I think in our rules, I think there's a rule that says it is not objectionable just because it goes to the ultimate issue. So I would read your rules. I would go back to that. But I think if you get that objection, if it doesn't go to the ultimate issue, then that's what you say. Your Honor, the ultimate issue in this case is, whether so-and-so committed negligence. This question does, he's not saying whether they committed negligence. He's talking about one of the elements or whatever it goes to. I've never really seen that objection used, but I'm pretty certain in your rules, you've got a proviso that says it's not objectionable merely because it goes to the ultimate issue. So I'd check your rules. How do you defend yourself if someone brings up a rule that you don't know during an objection? Well, it certainly should be a rule in your evidentiary rules. But again, this goes back to reading and understanding the rule. I've seen scenarios where sometimes the rule is referred to as something you never heard from. For instance, I was in New York in a mock trial competition, and I got objection over the shoulder, and I had never heard of that before. And so I actually asked, Your Honor, I am not familiar with what over the shoulder means, but I'm happy to respond if I can get some clarity, or if counsel will explain what they mean. And what they were meaning was I was attacking counsel. I was making statements negative about opposing counsel as a way of trying to hurt their case, which I was, but it was for good reason. And so, but I've had that happen before, where it's just, there's a statement I've never heard of the way the rule has been called before. Just ask for clarification. All right, I'm happy to respond to that. I just am unfamiliar with the term over the shoulder. Now, don't say I'm happy to respond. I'm unfamiliar with the term hearsay. That would probably be bad. But always ask for clarity, because it shows confidence. Like, I've never heard that phrase before, but I'm happy to answer. But otherwise, I mean, you got to try and do the best you can. I mean, certainly don't just concede the objection, but the best way to handle it is to know the rules better, and to have understood them. And I'll give it to you with the fact pattern and the rules. It's a lot of stuff to go through, but you can see, I think, through all this, what a massive advantage a team has when they know the rules better than the other team. Or if you've had any experience where that one lawyer on the other team, who is, the apparent rock star, knows those rules so well that when they object, you tense up, you get nervous. That's an advantage, right? That's an advantage you want. And you can get that by studying the rules and digging into the rules and learning how the process works. And it takes a long time. It is harder than learning the fact pattern, but that's what your attorney advisor is there for. It's what your teacher advisors are there for. And, I think there are treatises that help explain mock trial evidence. I don't think that's improper, because you're not, that's more of a understanding of the rules. I mean, you can even go to the actual federal rules if you felt like it. You're not gonna be able to cite any cases to the judge, but anything that helps you understand the rules, I think, is totally permissible. But I'll warn you, there are plenty of rules in the federal rules that aren't in our rules, and other mock trial rules that aren't in there. But you should be able to find, if you want, people who explain the rules. Hell, I mean, first year or second year evidence classes in law school, there's treatises on that. That can be helpful if it furthers your understanding of the rule. Again, you're not going to be able to cite a case about something, some famous case, but understanding how hearsay works will allow you then to extrapolate it, or relevance, or subsequent remedial measures, into the specifics of the case. And I think that's a great way to do it. Let's see. Okay, we got 5 minutes. Let's see. There was a question about, what is it, 612, I think, or 613. This is my little mock trial book from back in the day. A witness's prior statement. Yeah, I don't think, one, you need not disclose to the witness, but must show it or disclose to the adverse party's attorney. Everybody has the witness statement, so I don't think A is going to ever apply in this. Extrinsic evidence of a witness's prior inconsistent statement is admissible only if the witness is given an opportunity to explain or deny. I mean, I remember that from evidence class. I don't think these are going to apply. I'm actually not even sure that they're in your rules, but to the extent that they are, I would refer to your attorney coaches for really nitty-gritty stuff on some of these rules. But I definitely have never heard anybody use that, and I'm not sure that that's in your rules. But I apologize because I haven't used that rule in forever. When would be the best time to object if you believe the other team broke a mock trial specific rule, unfair extrapolation, if the other team was using a proper costume? If they're using a proper costume, I'd object immediately. I don't think I haven't seen teams do that because I think it's so obvious. They're wearing glasses or a mustache and it's not real, or, I mean, you can play the character, but a police officer can't show up in a police uniform, right? Like, that is absolutely a costume. Doctor can't show up in scrubs. So I think that one is pretty obvious. Unfair extrapolation, forgive me because I feel like I looked at this rule last year. I believe the rules define when you're supposed to make that objection. But if there is questioning or statements that are going on that are unfair extrapolation, subject to my proviso that I need to double check the rules if there are statements on it, because I haven't looked at that in a while. I think you bring it up at the moment. I mean, I think you say, Your Honor, I'm going to object under the mock trial rules. The statements the witness is giving are unfair extrapolation. They are not reasonable. They're not contained in the witness's statement, and they are not reasonable inferences. Because I think once you do that, if I'm the judge, I'm going to turn to the other side and say, okay, tell me where in the witness statement all of this, one, it needs to be like something at issue, right? Not that your mother was a gardener, right? That has no it's not gaining them an advantage. But if it's something they're using to gain an advantage, if you say, I'm going to turn to them and say, where in the fact pattern, where in the witness statement can I infer this from? And once this goes, I think I talked about this in the last thing about unfair extrapolation. Man, you need to be real careful if you're trying to extrapolate things from the witness statement. Because if you get caught unfair extrapolating, I mean, I think that's going to be grounds for like the 5-point penalty thing. Like, I mean, because you have so much in the fact pattern, you have so much already to use that if you unfair extrapolate and are gaining an advantage, you're going to get dinged. And if you've relied on that for 3 trials and you only got caught in trial 2, you're going to have to change for trial 3. Because if it's a big issue, the judges will know about it. Because that's the easiest, other than like communicating with a coach or with somebody during trial, that is the preeminent form of cheating. And so I would be very careful trying to pull things out of a fact pattern other than reasonable inferences, because you're going to get dinged hard if you cross the line. Seen a witness wearing a lab coat to court. Do we just point out to the judge that it's against the rules or anything specific they're playing a doctor? I mean, I don't recall that from this competition, but that's something that, that's something I bring up in housekeeping, right? Is there any issues from the parties? Like in that preliminary step, Your Honor, the student playing Dr. So-and-so is here wearing a lab coat. We believe that constitutes a costume, which is impermissible under the Texas mock trial rules. Done, right? Certainly don't let them get up there and talk about it, or talk the entire time on direct, and then you make your objection, because at that point you've almost waived it. But if you see somebody wearing a costume, I think that's perfect to bring up in housekeeping, right? Housekeeping being the time when, maybe permission to move about the well, witnesses be sworn, that time. All right, that's 12. thank you guys all very much. I'm going to close this room. We're going to go, it's going to push you back in the main room, but frankly, I'm just going to tell you all thank you very much and you're free to leave. So if you just want to log out now, that's fine. But